Hello, everyone. Welcome to our final session of the Oxford Jurisprudence Discussion Group. It's a session that unfortunately we had to postpone, but we are very happy to do it, in an online format today. We have the pleasure today to welcome Signe Larsen. Signe is a fellow by examination at Magdalen College, Oxford. If you haven't read her book, The Constitutional Theory of the Federation and the European Union, that was published by Oxford University Press last year, I really encourage you to do so. Today we will be discussing a paper, European Public Law After Empires. So thank you very much, Signe, for joining us today, and the floor is yours. You can begin.
So good evening, everyone. And first of all, I really want to thank Cecile, Mauricio, and Andreas for this very kind invitation to speak here today. I've been looking very much forward to this event. I also want to tell you that I'm really sorry that I couldn't be here in person tonight. I was really looking forward to getting to know all of you and to talk in a more informal way over drinks. So I've put my email address on the slides, and please do feel welcome to contact me if you are interested in my work, and if you want to meet and talk more, I would be happy to do so. So it's really a great pleasure for me to speak to you tonight, because it's given me the opportunity to present my current research project, which this article is a part of. And this project is about empire and public law. And what I explore in this research project is the historical transformation of European public law from empires to European integration. And I hope I can give you a sense of what this research project is about tonight. For those of you in the audience who are public lawyers or EU lawyers yourself, I also hope that this can inspire you to reflect upon the significance of empire for your own research. So what I want to do in this project is to bring empire and decolonization to the heart of the study of public law, including European Union law. So the end of empire is one of the most significant geopolitical transformations of the 20th century, if not the most significant. And yet the academic study of public law is, for the most part, conducted as if empire never existed. So for example, when we teach constitutional law to undergraduate students at Oxford, empire barely makes an appearance on the otherwise long and very comprehensive reading list. And this is despite the fact that central concepts in constitutional law, such as citizenship, in the British context really only developed in conjunction with immigration law as a product of the end of empire in the 20th century. So the underlying account of the British Constitution is instead sort of that the UK is assumed to be a nation state, and more that it's been a nation state since time immemorial. And if you ask any historian today about this, they'll of course tell you that this is an extremely parochial account of Britain and the British Constitution, because for centuries the UK was the imperial metropole of the most powerful maritime empire the world has ever seen. The UK Parliament was also an imperial parliament that ruled vast areas and populations outside Europe. So this shaped British identity and British public law. And yes, it does not take center stage in the study of British public law today. As a metropole of a huge empire, it's not really meaningful to talk about a British nation state, or at least not exclusively so. The UK was rather the dominant center of a composite legal and political entity, ruling over multiple peoples who spoke multiple languages and belonged to many different religions. And I would actually push the argument even further and say that Britain has never been a nation state in any meaningful constitutional sense. With the end of empire and decolonization, the UK became a member state of another composite legal and political entity, namely the European Union. So between empire and European integration, there was no historical gap where sort of an autarkic British nation state could emerge on the world stage. So my view is that this is a public law background on which we should analyze and discuss the British Constitution today and the crisis of the identity of the British state after Brexit. This is really the first time in history where Britain is sort of more or less unmoored from large and influential composite legal and political entities, and without a large internal market to sustain the British state. I make this broad argument in my recent book that Mauricio kindly referred to earlier, The Constitutional Theory of the Federation and the European Union. And my basic historical argument there is that what the European states reached for with the end of empire was not the world of complete sovereign independent nation states, but rather what in historical terms always had been understood as the viable alternative to empire, namely federation. European integration became the answer to the problem faced by the European states, with the decline and the eventual collapse of European empires. My argument is that federation in general, and the EU in particular, is the alternative to empire. For that reason, it's a mistake to think about the EU and its member states as competitors in a zero-sum game, as is often the case, especially in the Eurosceptic press. That the EU is the successor and alternative to empire is painfully clear to the people of Ukraine today, and I'm happy to talk more about that in the discussion afterwards, if you like. But I gave the example of the UK today in the hope that it will resonate with you, because we today find ourselves in Oxford, or at least I do, at the heart of one of the institutions where many of the people who governed the British Empire were educated. But we could just as well have taken another European empire as an illustration. So here we have the French Empire. And the intuition of my research is really this: if composite legal and political entities are not nation states, are the dominant political form of association in global history, it should be the heart of our study of public law. So what I want to do with my research is to break away from a nation state-centric worldview and a methodological nationalism that shapes scholarship and make it impossible for us to appreciate our own public law order, including its transnational and European dimensions. When we do scholarship, we always take some categories for granted, and we have to assume the relative stability of some concepts. And we tell the story from a certain angle. We have to, because this allows us to save energy and spend time on some material rather than other, discard some information as irrelevant to what we do, and to present a coherent narrative. In public law and in EU law, but I would say much more broadly also in political science, the underlying methodological assumptions tend to be that the nation state is the only legal and political form of modernity, and that nations, French, the German, and the British, for example, are relatively stable transhistorical categories and subjects that have to take center stage in our historical narratives. So the most important thing I want to convince you of today is that this methodological decision, and it's really quite rare that it's even sort of acknowledged that this is a decision, leads to a fundamental misunderstanding of our current European public law order, including both the domestic constitutional regimes, but also the European Union, and that it makes us blind to our own history, importantly, the continual legacy of empire and public law. So I'm not arguing that empire and decolonization are not widely studied today, including by lawyers. There's a significant literature in public international law on decolonization, importantly, third world approaches to international law. But decolonization is widely studied as something that happened in the former colonies. In public law, we rarely turn the decolonial gaze towards the former imperial metropoles. We rarely ask, what did the end of empire mean for European public law? The assumption seems to be that the colonies were like an appendix that could be removed without also fundamentally transforming the imperial centers, the imperial metropoles. What I want to demonstrate with my research is that this is a mistake. If we want to understand the public law order of Europe, we have to reckon with the legacy of empire and imperialism in public law. The most basic point I want to convey to you today is that we should all care about understanding empire if we want to get a proper understanding of our current public law order in Europe. And in a really quite depressing way, the Russian invasion of Ukraine has made this argument for me. The Ukrainians are fighting for their lives and for their rights, but they're also fighting for a future as an equal member of the European Union and a European future for Ukraine, free from the imperial domination of Russia. Now, the paper I'm presenting today is part of my new project of empire and public law, but the focus is somewhat narrower than sort of the big story I've just told you. So the paper is written for a new interdisciplinary journal on EU law, and it will be published in the inaugural issue very soon. So the paper is written with a very specific audience in mind, namely scholars and students who have a strong interest and some knowledge about the project of European integration. And I appreciate that you might not be that audience because you do not work on the EU, but on other important issues of today. So what I will do now is I'll try to make sort of the broader point of the article rather than sort of the more limited contribution I tried to make to EU law scholarship. So the paper opens with a version of the story I've already conveyed to you. The project of European integration was agreed amongst three declining maritime empires: the French, the Belgian, and the Dutch, and two failed fascist empires, the German and the Italian. And yet, the official narrative put forward by EU institutions, as well as sort of the scholarly debate about the project of European integration, proceeds as if empire never existed. So in the paper, I give the example of the very prominent political scientist, Andrew Moravcsik, who's one of the few scholars who even mentions empire when he writes about European integration, even though he does it only to dismiss its significance. So Moravcik's argument is that the project of European integration was about commercial interest rather than imperial glory. But in this way, what he does is really that he perpetuates the old narrative about the white man's burden, which has been widely discredited by countless historians and social scientists, who have instead demonstrated that the central motivations that fueled imperialism were access to larger internal markets, natural resources, cheap or slave labor, and soldiers, as well as a safety valve for European overpopulation and land hunger. So instead of starting with empire, the academic study of European integration starts with a mythical story of European history that goes something like this. For centuries, the European nation states were in more or less constant war with each other. This culminated in the greatest nationalist war of all time, where atrocities yet unheard of in history were committed. But after the war, luckily, this led the European nation states to come together in a great peace project, namely the project of European integration, and thereby a new and unique legal order was created that over the years emerged as a rival center of governmental authority to the nation state. And here the story sort of diverges in two directions, depending on whether scholars give priority to EU institutions or to the member states. So on the one hand, we have sort of theories and narratives about functionalism, cosmopolitanism, constitutionalism beyond the state. And on the other hand, we have theories of intergovernmentalism, realism, and the EU as either administrative law or international law. And where sort of the former cluster of theories sort of look with admiration on the European Union as an exciting project that finally managed to transcend the horrors of the nation state, the other groups of theories argue that notwithstanding the significance of the European project and globalization more broadly, the nation state really sort of remains the most important political unit of analysis. So there are, of course, like fundamental differences, really significant differences between these two clusters of theories that sort of dominate European integration studies. Most importantly, whether or not the nation state is withering away and whether that is something we should be happy about or not. But my point really is that all these theories share the same underlying historical account of European history, which tell us that the nation state is the dominant, if not the only form of political association. And my argument is that we should reject this story because it completely ignores the significance of empire in European history. So from a historical perspective, the dominant form of political association is empire. It's not the nation state. And in contrast to the nation state, the empire is a composite legal and political entity. And as an illustration, I have, chosen this map that shows some of the diversity of the multinational, multilingual Habsburg Empire. But I might just as well have showed you another picture of the British Empire or the French Empire to show you this sort of diversity consisting in that sort of included in empires. So my point really is, if we take into account that political modernity has overwhelmingly been shaped by the political form of the empire, the notion that Europe today is governed by a legal and political system that does not conform to the model of the sovereign nation state, it already appears less unique. So if we accept that composite legal and political entities are not exceptional, we are forced to conclude that if the EU is unique, it's not because it's a composite legal and political entity. But the dominant narrative in my field is exactly that the EU is unique or sui generis. So the argument is that within the international legal community, states are sovereign and equal, but by introducing the principles of supremacy and direct effect, the argument sort of is that EU law, and especially the case law of the European Court of Justice, has introduced a legal revolution that has taken EU law beyond the realm of normal international law. So the EU rather constitutes a new legal order that eludes traditional concepts of international law. The EU has led to an erosion of sovereignty that scholars look on either sort of with grim concern as an undemocratic force, or else as a promise for a new form of cosmopolitanism that ought to be replicated all over the world. And my view is that there's no doubt that EU law is distinct from international law, and it remains a minority position for very good reasons. But that being said, the significance of EU law is often missed by the literature because the narrative lacks historical depth, including an understanding of the role played by empire in the historical transformation of the European public law order. So when scholars say that they think the EU is unique, they compare it with the contemporary global legal order of universal international law, where more or less the entire globe is parceled into nation states. And compared to this global order, the EU appears as a mystery, somehow more than an international organization, but less than a sovereign state. But this global order in historical terms is recent. In fact, it's more or less as old as the project of European integration. So if we want to understand the significance of EU law, we have to compare it not merely with the contemporary global legal order, but also with the global legal and political order that preceded European integration. Because for most of modernity, European jurists would have found it absurd to think of non-European political communities as sovereign. Sovereignty only pertained to the civilized, that is, European world. And this view really continued in some form until the 1960s, when non-Western political communities at large were included in the family of sovereign nations as part of decolonization. So the universal international law that the EU is contrasted with, where sort of the default option is that political communities on a global scale are recognized as sovereign states, only came into existence as a consequence of the collapse of the global legal order of European empires. So what I try to show in the article is that from a historical perspective, it's really neither new nor unique that there's a legal and political order that differentiates the governmental relationship between European states on the one hand, and sort of the relationship between Europe and the rest of the world on the other hand. On the contrary, that has always been a core feature of European public law. But the configuration of that relationship, the type of legal regime governing what I call the dynamic of difference, has undergone a significant historical transformation. So my point here is really, my fundamental point is really methodological. What if we do not take nation states as transhistorical objects of study, but rather focus on the legal and political regime that has governed Europe as an entity, by which I mean intra-European relations, as well as the relationship of Europe to the outside world. So that is, what if we start our inquiry by looking not at Britain, France, or Germany in isolation, but rather at the European public law order as a whole, and try to understand how that has transformed historically. So what I try to show in the paper, and here I build on work done in public international law scholarship, is that international law in its origins is Eurocentric. So in the 19th century, international law, which regulated the relationship between European states, and domestic constitutional law, which regulated public law matters within the European states, were understood as the internal and external aspects of the European public law order, droit public de l'Europe. So French scholars had talked about droit public interne and droit public externe, and German scholars talked about inneres Staatsrecht and äußeres Staatsrecht. And today we still talk about the internal and external aspects of sovereignty. So these are really sort of co-constitutive aspects, the internal and internal aspects of the public law order. But what is unfortunately sometimes sort of ignored is that this world of European public law only included what was seen as civilized nations, meaning predominantly European states, and later former white settler colonies ruled by white people of European descent. So only European states were civilized, and for that reason, only European states were sovereign. So outside the world of the family of civilized nations, a very different legal understanding structured the relationship of the colonial encounter with uncivilized people. So because the non-European peoples in the eyes of Europeans and European jurists were not considered civilized, that the land was open to the discovery by Europeans. The uncivilized peoples could, per definition, not exert sovereign authority over their lands, and for that reason, even where sort of land occupation took place by a treaty, the colonial people could at best be regarded as having private law ownership over their land, never sovereign authority. So there were therefore three sort of main tenets of the European public law order. There were European domestic constitutional law that governed domestic European affairs, European international law that governed intra-European relations, and then colonial law governing the colonial encounter with the uncivilized world outside Europe. So the interstate character of European international law can really only be understood if the spatial order that underpinned it is acknowledged. So the old world of Europe, where states recognized each other as sovereign and equal, relied on its differentiation from the New World, where for most of political modernity, no communities were recognized as sovereign, where the law of civilization did not apply. So it was really this fundamental difference set out in 19th century European public law that gave meaning to the structure. The European princes could recognize each other as equals and sovereign exactly because they saw themselves collectively as distinct from and superior to non-Europeans. So the point really is here, and this is sort of what you get from the public international law account, is that empire is not sort of an incidental feature of the European public law order. It's constitutive of it in the 19th century. And my contribution here really is to say, well, my view is that European integration is integral to the broader transformation that took place with the decline and eventual collapse of European empires. With the decline of European imperialism, the old world of European public law, the old world order, with its idea of European international law, gave way to a new kind of international law, universal international law, where for the first time in history, more or less all political communities came to be recognized as sovereign states as a product of decolonization. But the decolonization in the imperial periphery was not the only way in which the public law order was transformed with the end of empire. The collapse of European imperialism also instigated a fundamental transformation of the public law order of the European metropoles. So in a nutshell, my argument in this paper is that if the end of empire led to decolonization in the imperial periphery, it led to European integration in the imperial centers. European integration was integral to managing imperial decline and eventually also to replace or be part of the replacement of the European public law order that was grounded in empire. So in this paper, and I can talk more about it in the Q&A if you like, I argue that the post-Second World War European public law order has three tenets. So first, there's a new type of anti-totalitarian domestic constitutional law, which aimed to constrain sovereign power internally by insulating certain aspects of political decision-making from ordinary politics. Second, a new European legal order founded on the limitation of sovereign power, which sets sort of intra-European relations apart from normal international law. And third, sort of the reconstitution of Europe's relationship to the former colonies, importantly through the realization of a version of the interwar project of Eurafrica. And my argument is that European integration was central to all these three tenets of the new European public law order. So the basic point that I want to impress on you is that in the moment in history where sovereignty was extended to non-European political communities through decolonization, Europe turned away from the old master principle of sovereignty, both with regard to domestic constitutional law and with regard to intra-European relations. But this turn away from sovereignty was not merely a response to a fear of nationalism, as is often argued in the literature, but also an attempt to reassert European interest and the geopolitical autonomy of Europe in a world where Europe was no longer the center of gravity. When the European empires no longer were able to assert their domination as individual empires, European integration allowed them to assert their interest collectively vis-a-vis the new developing world. So by carving out a new space for Europe in a world in tandem with decolonization, European integration emerged as part of the solution, the European solution to the humiliation suffered by the European states with the end of empire. But the legacy of empire for the project of European integration is largely ignored or forgotten today. It's really rarely mentioned that the backdrop of the project of European integration was not merely the decline of the maritime empires, but also the attempt to reassert the old imperial privilege of Europe, importantly through the revival of the idea of Eurafrica. And you have two maps here that you can have a look at. I would say on the contrary, actually, the official narrative about European integration sort of has allowed the member states to tell a comforting story about themselves that leaves out the tainted history of colonialism and empire. And it's sort of this comforting story, this founding myth of EU law, if you will, that I want to question in my article and my research more broadly. So as should be painfully clear to you by now, I'm not engaging in normative work in contrast to what I assume many of you are doing. What I try to do is really to provide an analysis of the European public law order anchored in law and in politics, history and international relations. So my aim is to demonstrate what I believe is the true significance of European integration as both the successor, but also the eventual alternative to empire. And as all sort of significant political projects, the project of European integration has darker legacies that should make us feel uncomfortable. And my view is that we should reflect upon them in a nuanced and critical way, because only then can we hope to begin to understand our current moment in time and the crisis we are currently facing. So thank you very much. This is all I had to say.